evening. I call this hearing to order. My name is Richard Geller, and I am special magistrate appointed by the city of Cape Canaveral. Today's date is June 23rd, 2020. I'm appointed pursuant to Article 6 of the City Code and Florida Statutes, Chapter 162. This is a quasi-judicial evidentiary proceeding. The burden of proof is on the city to show by a preponderance of the evidence that a code violation exists. In other words, I will determine, based on the evidence presented to me this evening, whether it is more likely than not that a violation has occurred. The alleged violator will be given an opportunity to submit any rebuttal or exculpatory evidence, including any testimony. At my discretion, I may allow a member of the public with relevant personal knowledge to testify, even if not called by either the city or the responding party. And anyone who would like to testify should sign the sign-in sheet, which is at this front table where I'm pointing. Upon request, an alleged violator may ask relevant and material questions of any city witness, and the city may ask relevant and material questions of any witness for the responding party. I may exclude evidence that I deem irrelevant, immaterial, or repetitious. If I determine that a code violation has occurred, I may issue an order requiring that the violator take whatever steps are necessary to bring the violation into compliance. I may require compliance within a certain period of time, after which a fine will be assessed. In determining the amount of any fine, I will consider the gravity of the violation, any actions taken by the violator to correct the violation, and any previous violations committed by the violator. Under the City Code and the Florida Statutes, I may assess and order the payment of a fine of up to $250 per day for a first violation and up to $500 per day for a repeat violation, and in the case of irreparable and irreversible harm, a fine of up to $5,000, as well as the cost of any repairs made by the city. At the conclusion of the hearing, I will issue findings of fact and conclusions of law based on the evidence of record, and will thereafter issue an order, both here on the bench and in writing. The city may record a certified copy of any order imposing a fine, which will become a lien against the land where the violation occurs, as well as any other real or personal property owned by the violator. Any order I issue may be appealed by any party to the Circuit Court for Brevard County, Florida, within 30 days. It is the responsibility of the appealing party to obtain a record of these proceedings. An appeal is limited to the record presented before me. The first item of business that I have is to establish the next meeting date, and that will be July 28th, 2020, also at 6 p.m. Here in Chambers. The next item is the approval of the meeting minutes from February 25th, 2020, and I have approved these minutes and have signed them and will present them to the hearing secretary at the conclusion. So the first case we have is case number 2020-70, and I'll let the city proceed with its presentation.
Yes, sir. Good evening, Your Honor.
Good evening.
This is case number EN 20-70, City of Cape Canaveral versus Rita M. Goldberg Life Estate.
I wonder if you could just move the microphone a little closer to your...
Yes, sir. Is that better?
That's much better. Thank you.
Yes, sir. Case number EN 20-70, City of Cape Canaveral versus Rita M. Goldberg Life Estate. I'm John Mayberry, Code Enforcement Officer.
Yes, let's go ahead and do that. And will anyone else be testifying this evening who's in
I don't see any.
Chambers? Okay. And Do you swear that the testimony you're about to give shall be the truth, whole truth, and nothing but the truth?
I do.
Thank you.
Yes, sir, as stated, this is case number EN 20-70, Rita M. Goldberg Life Estate. Address is 403 Harbor Drive, Cape Canaveral. The legal description is there, as well as a parcel ID, and the violation is for property maintenance.
Okay.
The notification summary is as follows. On March 3rd, 2020, I sent a courtesy letter certified mail to the address for Rita M. Goldberg Life Estate. On March the 12th, I sent a notice of violation, which was returned to us to sender on May the 12th of 2020. The property was posted in accordance with Florida Statute 162.12. Notices Rita M. Goldberg Life Estate. Notice of hearing was mailed on 6/10/2020 to Rita M. Goldberg Life Estate, as well as a property being posted on the same date, 6/10/2020, again in accordance with Florida Statute 162.12.
Thank you.
This is a property appraiser's aerial view of the property. On March 11th, 2020, staff received a complaint regarding the fence, pool, yard at this residence. A site visit revealed the fence is in a dilapidated state with slats missing and others leaning over. Pardon me, we just had a update pop. Other slats leaning over or propped up. Visible through the fence line is a swimming pool, which is accessible due to the state of the fence. The pool water is stagnant and untreated. Grass and weeds in both the back and front yards exceed 6 inches in height.
Mr. Mayberry, is this a photo from outside the property or inside the
Yes,
property?
sir.
Is this outside looking in?
Yes, sir, outside looking in.
Thank you.
It's a little difficult to make it out with the lighting here, but this is the exposed pool. You can see it through the missing fence slats. Again, the water is stagnant and untreated in the pool.
Could you go back to that last
Yes, sir.
Slide briefly?
Yes, sir.
And does that, do you know what, it looks like there's I don't know if that's a chain link fence on the other side of the pool? Is there any kind of
No, sir.
remedial construction
No,
going
sir.
on?
No, sir. As a matter of fact, the doors that go into the house from the pool deck area were all open, and every time I've been by, they've been open. And there, as you can see in the fence photos, there's wide gaps in the slats. A child coming by easily access the area. This is the backyard, also visible through the fence, tall grass and weeds in excess of 6 inches in height. They're well over 18 inches in height. On May 13th, 2020, I performed a follow-up site visit which revealed that the fence remained unrepaired. They had taken some old slats, and you can see they had propped them up against the, trying to hold some of the boards in place. Also on May 13th, 2020, this is the posted notice of violation. And there's a view also of the notice with the garbage bagged in the front yard and tall grass and weeds around the house.
And what are the bags in the grass?
Just garbage.
Okay.
These photos are as of this morning, 6/23/20. Fence remains in a dilapidated state. Also, the yard remains uncut. And again, the pool remains untreated and unsecured due to the condition of the fence. I don't see anyone here from the
Well, I'll go ahead and ask, is anyone here for the Rita Goldberg estate to give testimony? Okay. No one has responded in the affirmative, so I'm going to assume that they're not going to show up.
Yes, sir.
Is there anything else?
No, sir, just staff recommendations.
Yes, what is your recommendation, sir?
Based on testimony and evidence submitted at this hearing, staff respectfully requests the magistrate find the respondent, Rita M. Goldberg, life estate, in violation as set forth in the notice of violation, and give the respondents until July 22nd, 2020 to come into compliance, or a fine be imposed in the amount of $100 for the first day and $50 every day thereafter until compliance is confirmed by the code enforcement officer, and all costs associated with the enforcements of the violation be imposed.
All right. Thank you, Mr. Mayberry. We appreciate that. I'm going to issue the following findings of fact, conclusions of law, and order based on the testimony that I've heard this evening. Regarding the subject property owned by the Rita M. Goldberg Life Estate, the mailing address, P.O. Box 45, Cape Canaveral, Florida 32920. The subject property is located at 403 Harbor Drive, Cape Canaveral, Florida 32920. I find that inspections were conducted on May 13, 2020, and on today, 6/23/2020. In addition to inspections before the courtesy letter was submitted on March 3rd, 2020, and the notice of violation that was provided to the Goldberg Life Estate on March 12th, 2020. The determination made by the city was that the property owner was not maintaining the subject property in violation of several city codes, which I'll review. Again, the notice of violation was submitted on March 12th, 2020. I find that the exterior of the property is not being maintained consistent with the property maintenance standards established in the International Property Maintenance Code, Section 302.7. The fence is dilapidated and falling in areas, and many slats are missing, which could allow access into the swimming pool in the backyard by a child. I find that to be hazardous and a risk to public safety, an imminent risk to public safety. The swimming pool itself, I find, is not being maintained consistent with the property maintenance standards established in the International Property Maintenance Code, Sections 303.1 and 303.2. The water is untreated, and there appears to be mold or mildew present on the walls of the swimming pool. And also I find that the grasses and weeds on the subject property are in excess of 6 inches in height. And so now I'm going to submit some conclusions of law. I find that the notice of violation was served via certified mail, which was returned undelivered. However, the property was posted. I find that Mr. Mayberry, the code enforcement officer, sent the notice of hearing to the respondent on, looked like it was posted on June 10th, 2020, and sent via certified mail the same day. Find that the notice for the hearing complied with Section 2-253 of the City Code, as well as Florida statutes, Sections 162.06 and 162.12. I find that the city adopted the International Property Maintenance Code, the 2018 edition, at the Section 82-221 of the City Code. I find that the respondent is in violation of the International Property Maintenance Code, Section 304.1, which states that the exterior of a structure shall be maintained in good repair, structurally sound and sanitary, so as not to pose a threat to the public health, safety, or welfare. I find that the respondent is in violation of the International Property Maintenance Code, Section 302.7, which pertains to accessory structures, which states that accessory structures, including fences and walls, shall be maintained structurally sound and in good repair. I find that the respondent is in violation of the International Property Maintenance Code, Section 303.1, which pertains to swimming pools, which states that swimming pools shall be maintained in a clean and sanitary manner and in good repair. I find that the respondent is also in violation of International Property Maintenance Code, Section 303.2, which deals with swimming pool enclosures, and it states that private swimming pools, hot tubs, and spas containing water more than 24 inches in depth shall be completely surrounded by a fence or barrier not less than 48 inches in height above the finished ground level measured on the side of the barrier away from the pool. Gates and doors in such barrier shall be self-closing and latching. And it also states that an existing pool enclosure shall not be removed, replaced, or changed in any manner that reduces its effectiveness as a safety barrier. And there were various changes made to the fence in terms of slats being placed on the side all around it. I find that the respondent is in violation also of Section 34-96D, as in David, of the City Code, which states that exterior property areas of all premises shall be kept free of all nuisances, litter, rubbish, debris, objects, material, or conditions which may create a health or fire hazard. Exterior property areas shall be free of unsanitary conditions which constitute a blighting or deteriorating influence on the neighborhood. Lawns, landscaping, driveways, and fences shall be maintained so as not to constitute a blighting or deteriorating effect on the neighborhood. I further find that the respondent is in violation of Section 34-122 of the City Code, which states that all grass areas and yards on improved property shall be properly maintained in a neat and attractive manner and kept free of dead plants, refuge, debris, and shall be further maintained further in a manner that such grass, weeds, and other rank vegetation shall not exceed 6 inches in height. I further find that the respondent had reasonable time, more than 3 months, in which to correct the violations identified in the notice of violation, which again was served on March the 12th, 2020. And so I'm going to issue an order that the respondent has until July 22nd, 2020, in which to correct the violations of the City Code on the subject property, and that the failure to do so shall result in a fine to be later assessed at $100 for the first day and $50 for each day thereafter, plus any costs incurred by the city. And so the respondent is ordered to secure the pool with a compliant fence and self-latching gate in accordance with the property maintenance standards set forth in sections 302.7 and 303.2 of the International Property Maintenance Code. The respondent is ordered to clean, sanitize, and treat the swimming pool in accordance with section 303.1 of the International Property Maintenance Code. And the respondent is ordered to mow and trim all vegetation on the subject property so that no vegetation exceeds 6 inches in height in accordance with section 34-122A of the City Code. That the respondent shall be responsible for providing notice to the City Code Enforcement Division of the Community Development Department that she has corrected the violations. If the respondent fails to correct the violations within the time set forth in this order, a code enforcement officer, such as Mr. Mayberry, may schedule a compliance hearing before the special magistrate. And in the event a compliance hearing is scheduled, the city shall duly notify the respondent of the compliance hearing in accordance with law. And at that compliance hearing, I would make a final determination that whether or not compliance has occurred, and if not, will impose the fines discussed earlier. Further, if the respondent fails to correct violations stated in this order, the city manager or his designee is authorized to expend funds in performing emergency repairs and other remedial work to abate the nuisance, which I've determined poses an imminent and continuing threat to public health and safety. And any expenses incurred by the city in performing such emergency repairs or other remedial work, including any contractor or material costs, administrative overhead, attorney's fees, or any other related costs, shall be subject to reimbursement to the city, and the city may impose a lien on the subject property. And that will be set forth in a written order to be issued. And the next order of business I have is case number 2020-102. Mr. Mayberry?
Yes, sir. It's case number EN 20-102, City of Cape Canaveral versus Lisa D. Taylor. The address is 111 Justamere Road, Cape Canaveral, Florida 32920. Legal description and parcel are provided here on the slide, and the violation for this case is property maintenance. April 23rd, 2020, the letter was returned to sender. May 15th, 2020, the property was posted in accordance with Florida Statute 162.12. Notice of hearing was sent certified mail on 6/10/2020 to Lisa D. Taylor, as well as a property being posted on the same day.
Was there any courtesy notice to her, any courtesy letter before the notice of violation?
No, sir, I had a couple of neighbors complain about it. It was pretty bad shape,
Okay.
as you'll see, so I went straight to a notice of violation.
Okay.
This is the property appraiser's aerial view of the property.
Okay. Could you just back up to the aerial view for one moment? The property line is shown as dissecting the pool. I assume that's an error and that the entire pool is within the subject property?
The lines oftentimes with the property appraisers, they're not always completely accurate. That's something we have to deal with.
But is it your professional opinion that the entire pool is within the subject
Yes, sir.
property? Thank you, sir.
On April 22nd, 2020, staff received a complaint concerning an untreated swimming pool and the associated wall and deck areas which are in a state of deterioration and uncleanliness. As you can see here, this is taken from Justamere Road. The fence is approximately 4 feet high. You can see this one section chipped and discolored. The pool is discolored. The water's untreated. Filters and the pumps do not work. I've spoken with the property manager, and her explanation was that was why the pool was in the shape it was.
So is someone residing in this home now?
Yes, sir. It's a rental property. Also, April 22nd, 2020, excuse me, but this is the pump and filtration system. And you can see the mold along the edge of the wall there and the decking. as well as the water. On June 10th, 2020, I posted the property. This is a photo of the notice of hearing is posted in the front yard. This is a photograph taken earlier today. Pool remains stagnant and unfiltered. The deck area is still uncleaned. The northern side of the wall on the property still remains unclean. And just for some contrast, that is the northern side, facing side of the wall. The western side belongs to the neighbors, the adjoining property, just to give you a contrast of what the wall should look like. The property manager was hoping to be here, but she called this morning and was stuck over in St. Petersburg, so she apparently didn't make it.
Okay. You said you inspected the property today. When was the first inspection that you performed?
April 22nd.
All right. Is anyone here present to testify or give evidence on behalf of Lisa D. Taylor? No one has responded. Is there anything you'd like to add before I issue an order?
The staff recommendations, all, Your Honor.
So it's going to be the standard $100 first day?
Yes, sir.
$50 the second day?
Yes, sir. And asking again
thereafter?
to be cured by July 22nd.
July 22nd, 2020. All right. Very good. Thank you, Mr. Mayberry. All right, I'm going to issue a findings of fact, conclusions of law, and an order. I find that the respondent, Lisa D. Taylor, is the owner of the subject property, which is located at 111 Justamere Road, Cape Canaveral, Florida, 32920. I find that the city lawfully conducted inspections of this subject property on April 22nd, 2020, as well as today, June 23rd, 2020, and determined that the property owner was not maintaining the subject property in violation of several city codes. I find that a notice of violation was provided to Ms. Taylor via certified mail, which was returned undelivered on April 23rd, 2020, and that the property was properly posted on May 15, 2020, with respect to the notice of violation, and with respect to the notice of hearing for this evening, that Ms. Taylor was served via certified mail on June 10th, 2020, and also the property was posted on June 10th, 2020, advising her to be here, and we heard testimony that a property manager was aware of this hearing. I find that the subject property has a swimming pool with stagnant and untreated water, that the swimming pool, the pool deck, and the walls surrounding the pool area are not being maintained consistent with the property management standards established by the International Property Maintenance Code, sections 302 and 303. That these areas, the water, the deck, and the surrounding walls are have mold and mildew. The water is untreated. Mr. Mayberry, were there any odors? I thought I saw that in the notice.
Yes, sir. That was a complaint initially by the neighbor.
Okay. Did you smell any odors yourself?
No, sir, not when I went by there. They said that it was really noticeable in the evening, at night.
Okay. Thank you.
Yes, sir.
I find that sufficient evidence to establish that there also are foul odors emanating from the untreated pool area. I find that the city adopted the International Property Maintenance Code, the 2018 edition, at section 82-221 of the city code. I find that the respondent is in violation of the International Property Maintenance Code, section 302.7, pertaining to accessory structures. And forgive the repetition, but I want there to be a complete record. And that section states that accessory structures, including fences and walls, shall be maintained structurally sound and in good repair, and that the swimming pool, its walls, and the adjacent deck and the surrounding walls are all accessory structures. And I find that the respondent is in violation of the International Property Code, section 303.1, which pertains to swimming pools, which states that swimming pools shall be maintained in a clean and sanitary manner and in good repair. I also find that the respondent had a reasonable amount of time, more than 2 months, in which to correct the violations identified in the notice of violation. And I'm going to order that the respondent has until July 22nd, 2020, in which to correct the violations of the city code. I'm ordering the respondent to clean, sanitize, and treat the swimming pool water, the pool walls, the pool deck, and the surrounding wall in accordance with the property maintenance standards set forth in sections 302.7 and 303.1 of the International Property Maintenance Code, and that the respondent is responsible for providing notice that she has corrected the violations to the code enforcement officer, and that if the respondent fails to correct the violation within the time set forth in this order, that the code enforcement officer shall schedule a compliance hearing before the special magistrate. And prior to that hearing, notice shall be provided to the respondent, and the respondent shall have an opportunity to appear and present testimony and evidence as to whether the violation is continuing on the subject property. At that time, I will make a final determination whether compliance has occurred, and if compliance has not occurred, will impose fines. And those fines shall be $100 for the first day that the property maintains out of compliance, and $50 for the second day and every day thereafter until the property comes into compliance. If the respondent fails to correct the violation stated in this order, the city manager or his designee is authorized to expend funds in performing emergency repairs and remedial work to abate the nuisance. And there is most certainly a nuisance with foul odors emanating from this pool area. I find that to be an imminent and ongoing threat to public health and safety. And any expenses incurred by the city in performing such repairs or other remedial work, including any contractor material costs, are subject to reimbursement from the property owner, and the city may impose a lien on the subject property for any such costs incurred. Any fines which may be imposed may become a lien in favor of the city on the subject property and upon any other real or personal property of the respondent pursuant to section 2-252E of the city code and Florida statutes, section 162.093. In addition, there was testimony that there appears to be a renter in the house. This would appear to be non-homestead real property, And non-homestead real property is subject to a code enforcement lien. Subject to a code enforcement lien is also subject to foreclosure pursuant to Florida statutes, section 162.093. And in the event of foreclosure, the city may obtain an award of costs, including reasonable attorney's fees. Mr. Mayor or anyone else from the city, is there any other business that we need to cover this evening?
Yes, sir, Your Honor.
Then I'll call the meeting concluded. Have a good evening, everyone. Stay safe.